a couple of weeks. And yet your circumstance would seem to suggest that that is not true, that that is not the full extent of the downside of that there is more cost. And sometimes that cost is borne not just in an inconvenience, but in someone being left vulnerable.
Yeah, absolutely. In my case, it would have compounded the problem. Of course, I was depressed. Who wouldn't be? Of course, I had nightmares. Who wouldn't after going through that? But to take away my basic human right of self-defense on top of all of that would just be devastating for someone like me.
Sometimes people will argue due process is great and everything, but with respect to the bad folks, well, we can't give them due process. Isn't that the problem with due process itself? I mean, if we're going to respect due process, aren't we agreeing up front that due process needs to be up front? It's not really due process if it's only after the fact. Is that right?
That is right. And I understand it can be very scary. I mean, I get it. I get it. I'm a victim of a violent crime. But like I said, if you truly believe that someone is a danger, they should be confined to a mental facility, but they should have due process. And that's why I support the Baker Act and similar laws that already exist all across the nation. Every state has a similar law to that because it includes due process. Your legal fees are covered. They're not under red flag laws. You know, I don't have $10,000 to cover legal fees. It can be very, very expensive. And with the Baker Act and similar laws, mental health experts are involved. That's not always the case with red flag laws. And I think that's very important that mental health experts be involved in that due process.
Mr. Koppel, does lack of notice and due process, it sometimes might go along with gun confiscation orders, doesn't this have some potential to increase the risk of harm, both to law enforcement officers executing the orders and to those who are subject to those orders?
Sure. I mean, you imagine a situation where officers, there's a ex parte order that's been issued and, you know, made on weak evidence and the guy's really not dangerous, but the confiscation order is served by the police showing up at somebody's house at 5 o'clock in the morning. You know, normally, and or a homeowner might think it was a burglary, and because he has no idea that anybody's coming to take his guns. And there's also a broader problem in how it erodes trust between law enforcement and the public. And this was talked about in one of the Connecticut studies that's quoted in my written testimony. When you have somebody whose guns are taken away and confiscated, the police show up. I've never heard of anything going on against me, but now there's a cop coming to take my guns. As some Connecticut state police officers have reported, these are often the guys who think of themselves as the most pro-cop. You know, they're the ones who are on the back the blue, on the side of law enforcement, understand it's a tough job, and then all of a sudden, the guys they thought they were their friends are there to take away their property when it's a complete surprise to the person. And then maybe a few weeks later, the person hires a lawyer, goes into court, they get their guns back. But in the meantime, it's been a very humiliating process for the wrongly accused individual. And law enforcement, who I've often represented in amicus briefs in courts and elsewhere, are so dependent on the cooperation and goodwill of the public. You know, that's the American model. We're not policing from above like in some other less free countries. So when these are done wrongfully, they really break that relationship and bond between the public and law enforcement that is necessary to successful law enforcement and public safety.
Mr. Koppel, there are a number of us, myself included, who have formed sort of a bipartisan coalition raising concerns in a related area of civil asset forfeiture, where in areas outside of firearms, we've raised concerns with law enforcement being able to take people's property first and then ask questions later, to take first and then provide some sort of process later. Due process, of course, has a higher expectation than that, does it not? And do you see tell me what you think about the parallel between this and that. In other words, if one is concerned about the potential for abuse and the actuality of abuse in the civil asset forfeiture arena, how could one not see something similar when it extends to the Second Amendment?
It's the same kind of situation. It is a similar kind of situation, and both have good intentions of trying to deal with a serious problem. Here, gun crime and civil asset forfeiture, it had always existed in kind of a minor way, but it really got ramped up in a huge way in the 70s and 80s because of the drug war. And of course, drug abuse can be very harmful, not only to an individual, but to society more broadly. And so the idea was, well, we need these tools to fight the drug lords and all this. And what happened was there were a lot of people whose property got taken who weren't Colombian drug lords or anything like that. And it was widely abused. And sadly, the courts, in their view of what the Constitution requires as a minimum for due process, generally said that's fine. So I would urge this, especially this committee of all committees in the United States, which is charged with defending the Constitution, that one of the reasons courts often defer to legislative judgments is they presume, just like Chief Justice Marshall said in McCulloch versus Maryland, that the legislature itself already seriously thought about constitutional rights and values. So I think legislators can and should go above whatever minimal level the judiciary will enforce in terms of the protection of people's procedural rights.
So insofar as we're talking about a due process right that is freestanding here, which I think we've agreed that there is, certainly a right doesn't lose protection by becoming a hybrid right. In other words, if you already have a freestanding independent due process right protected by the Fifth Amendment or the 14th Amendment's due process clause, you certainly don't see that any justification for diluting that right merely because you've added the Second Amendment into the equation by virtue of its involvement in the firearms arena.
Yes, at least as a policy matter, you would think due process would be all the stronger there. And of course, the analogy is, I'm sure you know, in the first Supreme Court's free exercise of religion jurisprudence, sometimes that free exercise of religion gets stronger protection when it's a hybrid in conjunction with the exercise of some other right.
Right, right. I've never quite understood the hybrid rights doctrine in the First Amendment context beyond what you just described, which is that it certainly doesn't get weaker when you compound one right with another. And I would maintain that that is no less true here. Consistent with the directive I was given from the chairman when he left to go vote, I hereby recess this hearing of the subcommittee subject to the call of the chair, who will be back momentarily. Thank you.
We are back. We're going to be joined shortly by Senator Graham and Senator Cruz at least, and perhaps others. And I will yield to Senator Graham when he arrives, but I have a few questions in the meantime. First, let me ask the panel, because I wasn't here, whether everyone got a chance to respond to Senator Lee's questions, or if there's anything else you would like to say while we're waiting for others to come back. Mr. Horowitz.
If I were available, I would just, I think it's important to make the case that in these situations, we're talking a lot about civil asset forfeiture. I'm not an expert in that law at all, so I can't claim to that. But I do know that the due process protections in ERPO laws are very similar to other civil orders, especially domestic violence orders, but also in some cases of civil commitment, as well as in child endangerment situations where there's an urgency to act. So I don't know that the analogy is exactly perfect for civil asset forfeiture, because I think what we're talking about here is danger to persons. So I think the analogy is a little different. And when you think about due process protections that have been upheld, you can see that in numerous other fields, the type of arrangement that's built here is available in other fields. And so I think we tried to build this with that in mind. And I just, and one of the things you think about Indiana's original law, in that law, firearm removal has been upheld even without a hearing, a temporary hearing to begin with. And when we built sort of what we see, Indiana and Connecticut were the first. And as we built the laws moving forward, we wanted to add that hearing at the beginning so that no firearm was ever removed without a judge looking at least at the ex parte, looking at the evidence. So I think there's more protection here than than some folks have looked at through this. And I think it's in line with what we've seen in longstanding domestic violence protection orders.
As I mentioned, I will yield to Senator Graham whenever he's ready to go.
Thank you, Mr. Chairman. Yeah, thank you very much. Very good hearing. Appreciate it. Mr. Koppel, is that right? You still with us?
Yeah, I hope so.
Okay. Well, I enjoyed our last engagement where we're trying to find a way on the front end and the back end to give adequate due process, but also address the problem. And I think the Indiana situation is a good one. Ms. Gozar, is that right? Your story made me think about, we want to make sure we're thinking this thing through and not go too far with it. But I've just come to believe, Mr. Chairman, like you have, that states who've adopted these laws probably are on the right track. The Cruz situation in Parkland, 30 visits by the police, every warning sign known to mankind, and they were powerless. And Governor Scott, working with the State House, passed a Florida version of the red flag laws. Indiana was one of the first ones to do this. And the situation where the young man had the shotgun taken because of his mental health status, but there was no implementation, is something that I'm sure we don't want to have happen again. So, Mr. Koppel, when it comes time to write a grant program, let's say, incentivizing states to go down this road on the due process front, you're advocating that there be a civil cause of action in case somebody is accused wrongfully or maliciously, that they can actually have recourse against their accuser. Is that right?
Yes, not a mistaken accusation, because everybody makes mistakes, including me, as we discussed earlier in this hearing. But a knowing false and malicious accusation.
Well, so I talked with the chairman about that. That makes sense to me. That if somebody is trying to ruin your life and accuse you of something you're not, then they'll have a redress. So I like that. The ex parte nature of the hearing, the initial determination by the judge to act, what kind of standard would you suggest we create there?
I'd say start with the federal rules of civil procedure, which generally disfavor ex parte decisions, but allow a judge to issue orders ex parte on a guided set of facts and findings about necessity. And particularly, why is the other person not here in court? Why didn't this person have notice? And sometimes the person seeking a temporary restraining order can give a good answer to that. And some on which I am not an expert.
No, I got you, but you got to pick a standard. That seems to be a good one to me. The time period between the initial determination and a full-blown hearing, what would you recommend?
I'd suggest we talk to prosecutors and including some of the witnesses here who have experience with this and say what is a realistic time period. On the one hand, we want to be expeditious. On the other hand, maybe there's some time needed to gather
Okay.
evidence.
All right. Based on your research of the existing state laws, which one do you think has done the best job of threading this needle, and why? And which ones do you have the most concern about, and why?
Vermont may be best overall, although Connecticut has some good features in it too, and especially the requirement that law enforcement investigate the situation on their own before filing a request for a petition. Colorado, with its providing for defenders, defense lawyers in this case, I think is a very strong model and not only helps the individual, but I think also may function as a deterrent to potential abuses. On the other side, I'd say Massachusetts has some of the weakest standards for due process. In New Jersey, actually, once you've got the person actually gets an in-person hearing and there's a confiscation order, it has the effect of being permanent, preventing the person from ever owning a gun again unless they come back into court and prove that they're not a danger. So I think the model Mr. Horowitz's organization has talked about, where the order automatically terminates after a certain period of time, it can be renewed upon new further proof about the individual at that new time, is the better way to go.
Okay, well, just sum it up here. I don't want to go over. Basically, you believe the most constitutionally sound way to do this would be not a federal law, but some grant program that would emphasize adequate and robust due process. Is that fair to say?
Yes, and I think that the states and localities have the resources to do this in a way that the federal marshals and others just don't have the manpower for, among other reasons.
Thank you.
Thanks, Senator Graham. Senator Cruz, did you have other question? Mr. Bencomo, you're a gun owner yourself. I'm going to assume you're a law-abiding one. Has Colorado's law been tied to mass confiscation of firearms from gun owners like yourself?
First of all, I am definitely a responsible gun owner, so thank you. And from what we know from today, obviously I'm not a scholar or a lawyer or an attorney. We have not seen mass confiscations. One area that we could do an improvement, I was glad to hear that we hit the high marks on that we're a good role model. Not only do we have defense lawyers, I would love to see federal funding so that we can ensure that there's PSAs, public safety announcements, and education for the additional responsible gun owners of Colorado.
Are you familiar with instances where it's been used to retaliate against people or vindictively by family members or business associates against each other?
I am not.
And it's been about a year since Colorado's law has been in effect, correct?
That is correct.
Notwithstanding that some counties have declared themselves to be Second Amendment sanctuaries, and some sheriffs have announced plans to block the law from being used. I understand quite a few have reversed their opposition after seeing how the law is actually put into effect. Is that correct?
That is correct. And that those citations are listed in my written testimony. I wouldn't be able to speak to them today, but they are listed.
Well, I thank you for coming here and talking about how it has saved veterans' lives, because they are at risk of suicide, and this law obviously has worked effectively to protect them. Mr. Horowitz, Mr. Koppel referred to your statute as one that seems to have been framed to meet the due process standard, and that it is based on the best examples of laws throughout the country. And he alluded to the resources necessary to implement such a law. Would a law from Congress that provided those resources and training encourage states to adopt the best kind of standards as you have advocated?
I think the federal government could do a lot to encourage the proper standards for these laws. I do think we've seen, and Kim Wyatt is the best example of what her unit does, but where there is robust funding, you'll see all sorts of services for getting these done, but also for the respondents and the petitioners. But what you don't see is that, for instance, outside of King County, where Ms. Wyatt works, the implementation is really different. And so what we're seeking is those federal resources to make sure that the same processes that we've seen work in Washington, well, in King County, can do in every county that needs this. And I will say that suicide, and from my testimony, you know that I care a lot about this. Some of the highest suicide rates are in rural counties, who are least able to afford the types of training, the types of investments that other counties have done. So I think as a suicide prevention tool, I think the federal government has a big role to play in providing that technical assistance, that training, and the resources to really develop a process so things don't fall through the cracks. But there's also the types of services that would make this really work.
We've been talking a little bit about the protective orders, domestic violence protective orders. They impose restraints on constitutional rights, do they not?
They certainly do, well beyond what a extreme risk protection order does. So domestic violence restraining orders can often keep you from your bank account, from your kids, from your home, and in some states, even on a temporary basis, your firearms. So what we're talking about here is just one slice of that, but based on the same standard. It's a very surgical type of tool here. And that's the point of this. And I was glad to see Mr. Koppel talking about ways that we can agree on this, because I do think we can do that. I think we can get there. I think we can make this tool safe to use around the country. I think we can meet, come to the middle and find agreement and make sure that we're saving lives.
I was encouraged as well, quite honestly, by his statement to that effect. And I thank him for his testimony today, but also his candor in describing what he knows and what he doesn't know, because not all of us are experts on all the facets of these laws. But just from a constitutional standpoint, the restraints on liberty involved in domestic violence orders, in fact, they are called restraining orders because they restrict liberty. The civil commitment statute, which takes away potentially somebody's liberty. There are all kinds of ways in which those fundamental liberties are impinged to keep society safe, and they establish procedures to do it so that those orders are fact-based, and a burden of showing those facts is put on the person who would seek to take away that liberty or any other rights. And that basic concept is what we have here. And the idea that an order expires if it is unchallenged or unverified within a period of time, and a firearm is then returned, certainly is a source of protection, is it not?
It is, and as Mr. Koppel said, we really believe that at the end of the order, the firearm should be returned. It should not be a complicated process. There are options to renew, but at the same burden as the original. The burden should not shift from the petitioner in those circumstances. If there's a renewal petition made, it should again be on the petitioner to plead the elements of the statute.
And in a certain sense, we can actually not only encourage states to adopt these kinds of statutes, but also elevate the levels, the quality of those statutes if we offer incentives for them to do it in the form of grants and other support.
Right. I mean, as Senator Cruz said, the states are all over, the laboratories of democracy, and there's different processes in different states. And I think you're starting to see some, a coalescing around some of the best practices there. And hopefully the federal funding could really improve that and make that, continue to make that process, that coalescing develop, so that the law, we learn for what the best practices are. We learn from people like Kim Wyatt what really works, and that we end up developing a program that saves lives across the country.
I think, Ms. Wyatt, I asked you earlier about the importance of resources to your unit, and you have a very well-staffed unit with experts and prosecutors and so forth, which has costs. Could you talk a little bit about the value that federal resources would have to help you implement the best practices of that unit?
Sure. And just to give a little context, we are evolving as our unit has grown since January of 2018. Last year in 2020, we had, I believe, 73 law enforcement petitions, ERPOs, and 6 were from families. So we realize on a daily basis the need to educate the public and educate the community, from faith leaders to school officials, therapists, medical providers, law enforcement throughout the whole state, and federal authorities or federal law enforcement as well. So there's a need overall to educate the public, because if you have a law and nobody knows about it, then it's not doing any of us any good. So that would be the number one thing, is to get a public education out. And then the second thing I think is really critically important is to have funding for individuals who are implementing ERPO laws in their state, or to be able to create a model policy for law enforcement. So law enforcement understands how are we supposed to serve these orders, which are very similar to other civil protection orders. But once we created a model policy and assisted law enforcement in our county, we had much more buy-in from our local law enforcement, because it was this tangible, attainable task. So I would suggest doing some of those things, but education is the number one thing. And then the second is to bring all the system players together, so that folks from the clerk's office where the orders are going to be filed, to victim advocates who may be reaching out to families to also guide their loved one who's in crisis to get some resources. I think that's critically important. And one area where we lack in our state is the need to have some money for individuals that are subject to the ERPO who need a behavioral health evaluation. Funding is needed to be able to guide those individuals to be able to get that evaluation, if it's court ordered, and to be able to get them some help once they've been subject to one of these orders. I think that's critically important.
Thank you very much. I'm going to yield to Senator Cruz. I have a few final questions, but in case he has to leave, I'll yield.
Thank you, Mr. Chairman. I've got a couple of questions. Let me start with Mr. Koppel. Mr. Koppel, since you testified 2 years ago, additional states have enacted red flag laws, and multiple states have amended their laws. And it seems that they've all amended them in the direction of providing less protection of due process and less protection of Second Amendment rights. For example, California amended its law to allow a disgruntled coworker to initiate the process for confiscating a fellow coworker's firearm. Do you agree that the trend is for these laws to get broader and broader and less protective of fundamental rights? And if so, why do you think this is happening?
Oh, because maybe it's the slippery slope that always happens on all kinds of laws, is people get it enacted in one way and saying, look how narrow it is. And then when it's there, then they start thinking of ways how to broaden it further and further. And again, I think Connecticut has the right approach on saying anybody who's got a concern about someone else can come to a law enforcement officer, a peace officer, or a state's attorney and bring that problem forward. But they can't, just because you had a fight with a guy at work, you can't file a petition yourself against that individual. And law enforcement is supposed to do its own independent investigation. And that seems the best way to start off the process at the beginning with a higher quality of information to give to the judge.
Thank you for that, and I think that's a very good point. As we discussed earlier, I'm a strong believer in federalism, and right now, 19 states and the District of Columbia have red flag laws, and there's not much quality evidence about their effectiveness or lack thereof. Although there's some good evidence demonstrating that they have a very high error rate. Could you give a bit more color on what the evidence and the data shows about these laws?
So for a lot of folks, the RAND Corporation's continuing project on assessing, doing a meta study of all the social science on the gun issue has found some things, particular gun controls, to be effective. And in their evaluation of this, their view was none of the studies that exist so far meet our standards for data quality and persuasiveness. So there, on the one, there's nothing there from Rand's point of view. But even beyond that, I don't know of any study that's ever said there's a statistically noticeable change in crime or mass shootings, along with other crimes. But I'd also say that you don't have to, a law doesn't have to be proven to have a statistically significant effect to be beneficial. If you reduce homicide by 0.5% in a state, that may be, statisticians may not be able to see that and know that there's a cause and effect, but that's still a beneficial thing to do. The suicide data is mixed. One study said that it went down, firearm suicide declined in Indiana and wasn't replaced by other methods. Another study found in Connecticut, actually firearm suicide did decline, but other deaths by other methods went up. On that, it's really important to know that there are lots of nearly as lethal substitutes for firearms, such as hanging, that have very high mortality rates as well. The theory that for every 10 or 20 of these confiscation orders that gets issued, one suicide was prevented is really just a hypothetical extrapolation, and it makes the mistake of saying that every form of self-harm was a suicide attempt. You know, a teenage girl who cuts her arm isn't trying to commit suicide. She's certainly indicating she's got a serious problem, but that 10 or 20 to 1 figure is not supportable because it assumes that every form of self-harm is an intentional suicide, which is definitely not true.
Thank you. Ms. Gosar, in your opening testimony, you testified that red flag laws can have a chilling effect that can cause victims to fear losing their rights if they seek help by talking with friends or family or psychologists. Can you elaborate on that concern, please?
Sure. I think that when people fear that, someone may be very, very, very depressed and still be concerned for their own safety, which I'm sure to some people that doesn't make sense. But when people are concerned that they're going to lose their rights, they bottle up. Like they're not going to want to share their feelings. And I just think it's best that these people be able to get, mental health help. And if they feel intimidated, if they feel like they might lose their rights, it could actually have the opposite effect from what you want.
And advocates for red flag laws often focus on the benefit of removing a firearm from a potentially dangerous person. And there's no doubt that with someone with serious mental illness or an intent to do real harm, that can be a very real benefit. But they also diminish the harm of removing a firearm from someone who might be a victim of violence, for whom that firearm might be the difference between surviving a violent attack and not surviving a violent attack. Do you agree with that?
Um, yeah, I've got to tell you this. I think, and I've gotten to know a lot of victims. I actually brought my friend Amanda Collins Johnson with me. She's sitting just behind me here. She was brutally raped on her college campus. It was, of course, a gun-free zone, and it was in the student parking garage. She had her permit to carry, but because she was obeying that gun control law, she left her gun at home. She wasn't allowed to have it on campus. And that's where a serial rapist found her on her way to her car in the student parking garage. And he brutally raped her right there in the garage. And uh, I've gotten to know a lot of other victims, and they all want the ability to protect themselves, but we also fear that, some of our attackers are going to be released. People seem to think that if you do a horrible violent crime that you're just going to be in prison forever. That's not true. Murderers, really horrible people that do very violent things, they're let out of prison every day in this country, unfortunately. And that's very scary for us. And victims want to be able to protect themselves. But here's a scenario perhaps you've not thought of, which absolutely terrifies me. When my stalker, my husband's murderer, is released one day, what would prevent him from taking out a red flag on me to purposefully disarm me so that he can harm me? That's terrifying. That's just something to think about.
Well, thank you, Ms. Collins Johnson, for having the courage to be here and allowing your story to be told. And Ms. Gozer, thank you for speaking on her behalf and on behalf of so many victims of violence.
Thank you.
Thank you, Senator Cruz. I'm struck as we come to the end of this hearing by the points of agreement, perhaps unintentional. Ms. Goser, your point about people who have mental illness, perhaps being reluctant to talk to friends or professionals, is exactly the point that Senator Durbin made. I don't know whether you recall, but he said people should not be separated from firearms simply because they have a mental illness. It's dangerousness, it's risk, it's potential harm to others. That murderer would have no basis, none, for going to a judge and saying, Nikki Goser is dangerous, a risk of harm to anyone. On the contrary. And likewise, Senator Cruz and I are both Federalists. I was a state attorney general for way longer than I've been a United States Senator. I believe in states' rights to enforce their own laws, indeed to make their own laws. And that is the whole purpose of our proposed red flag statute. Not only to encourage states to make their own laws, but to make them better. So when they do pass their laws, they look more like, thanks to Mr. Koppel for his compliment to Connecticut, more like Connecticut than, say, one of the other states that he found less protective of constitutional rights. If they're going to be laboratories of democracy, better to elevate the results of those laboratories than let them kind of muddle along and fail to protect the rights of American citizens. So I think there's a lot here where we have common ground, as long as we don't become distracted. And I understand your point about gun-free zones, about permitting the most heinous kind of lawbreakers, perhaps to go free and threaten others. We ought to prevent that. But we're talking here about a more narrowly crafted law with a more narrow purpose that can be surrounded by all kinds of protections relating to what has to be proved in the way of factual evidence, the standard that has to be met, not just probable cause, the protections for individuals. You know, you could say that someone who's unable to afford an attorney has to be provided with one. I'm just thinking out loud here. But my hope is that we can go forward and sort of focus on the common ground, because if we do want states to be the laboratories of democracy, better to make them good laboratories and protective of constitutional rights than allow them to just go forward without encouragement to adopt higher standards. You know, I think Mr. Koppel has been very frank on the issue of whether there are authoritative studies. A lot of the evidence here is anecdotal. It relies on common sense. But if somebody says, I'm going to shoot people in Parkland, I'm going to kill students, and as Senator Graham has said, the shooter practically took out an ad in the newspaper and said, I'm dangerous, that it makes sense to give the police, and I take his point about the police, which is in the Connecticut statute, the authority to make their case, maybe screened by a prosecutor, as happens in the state of Washington. We've heard Ms. Wyatt describe that procedure with all kinds of protections and bells and whistles, rather than allowing that shooter to just go ahead. So I think I am determined to try to seize that common ground and make the case that we can work together on these kinds of statutes. I'm willing to hear from any of the witnesses who want to make any sort of final remarks, or Senator Cruz if he has anything. Mr. Horowitz?
I just want to thank everybody from the committee, for Mr. Chairman, for the ranking member, for giving this a fair undertaking. And I really believe that we can reach an agreement here. I think it's important to save lives. I think we can protect due process. We can protect constitutional rights and save lives. And for everybody on this panel, I think we want to come together, and that's what we want to do, is save lives. And I hope the members of this committee can hear what we've taken today, craft something that really works, and save lives. So thank you for this time. I'm deeply appreciative of being here today and for this very serious consideration.
Thank you. Thank you to all the witnesses. Thanks to Senator Cruz and all the colleagues who appeared here. The record will remain open for 1 week, and anyone with questions can submit